All right, let's talk about the cases I've had you to brief. I deleted Roland versus Christian, but if you went ahead and did that one, just go ahead and turn it in. I'll give you some extra credit. Just let me know you did it when you submit your paperwork, so I don't miss it if you submit it all at once. I'm going to give you a little extra time to get this done so you can do it at your leisure. So let's go through the cases here. The first one is one of the most famous cases in tort law. It's the United States versus Carroll Towing. And all these cases, they came from what we call case books. Okay, these are the books that you get when you go to law school. And you know, if you look on Lexis or Westlaw, or you actually pull these off a shelf at a law library, they would have all the head notes for you and the case syllabus and the rules of law and all that, and it would make it a lot easier for you to do the brief. I'd recommend that you don't do that, and especially if you go to law school, don't do that. You can actually buy books that do the briefing for you. But that's a shortcut, and you don't learn to analyze cases and think like the lawyer. So that's why, and these are excerpts from the cases. These aren't the full cases. Most of them are just part of the case. And so I recommend that you don't do it the easy way, but I can't certainly stop you. When I do this class in in the classroom, I just hand them out and make them do them right there. Okay, so let's start with U.S. versus Carroll Towing. Okay, we're going to use the IRAC format. We're going to start with the facts, the issue, the rule, the application of the rule of law, and the conclusion. Okay, and sometimes these things are in the right order, sometimes they're not. Okay, so let's start with the facts of this case. Okay, what happened in the U.S. versus Carroll Towing is there was basically a barge, and it was stuck in the middle of all the other barges, and they had to drill it out, which means move other barges and then pull that one out. Okay, and the Anna C, the poor Anna C, which is still at the bottom of New York Harbor, broke loose of its moorings as they were getting out another barge. It cruised down the Hudson River and then hit another. Now, the problem with the Anna C is it was supposed to have somebody on board, and that guy wasn't on board. Well, you might ask, well, where was he? Well, this isn't in the facts, but I'll just tell you, okay? If you look at the case, this is 1947. It took a few years for it to get up to the appellate court, so this was in World War II. It was in New York Harbor. Probably the bargee, or the person who was supposed to be on the barge, was out partying, okay? And didn't get back the next day. Okay, New York was a very fun place during the war. Okay, so the facts are neatly summarized for you. Okay, now the issue that comes up if you read the case closely that Lerner and Hand has to deal with is there's just no really rule. Okay, so we're in the common law, and Lerner and Hand decides he's going to make up his own rule, and he comes up with the famous Hand formula. Okay, created by Justice Lerner and Hand. Okay, so if we look at the case, what law is he going to use? Okay, and if you look at the top of 37, he creates a new rule on duty. He says it's the owner's duty, whether he has a duty is a function of three variables. One, the probability that she will break away. Okay, so this is the probability that harm will happen. Okay. Two, the gravity of the resulting injury. Okay, that's the second part of the rule. What is the harm that could occur if the person breaches their duty? And the third one, the burden of adequate precautions. Okay, so this is the rule. This is the famous Hand formula to determine duty in a case. And all of these cases deal with duty. Okay, so the Hand formula, the way it works is if the burden on the person is less than the probability of harm and the magnitude of the harm, then there's a duty to prevent harm. Okay, so that's negligence. Okay, that's an element of negligence. Okay, so if something can happen is really bad, and it might be likely to occur, then there would be a great duty on somebody, even if the burden of preventing the harm is high. Okay, and you could use this in all kinds of different cases. Okay, so now how does he apply that? Well, he looks at, if you look down at the part that says A in 57, or down at the middle, at least on my case brief. Okay, a lot of these cases, these are my case books, and I briefed them in the book themselves. Okay, he reuses the facts, and this is why I love this case, because it shows you how you take the rule and you put it into the facts. Okay. Okay, now, what he says is, the bargee left at 5 in the afternoon the day before. It broke away at 2 in the afternoon the next day, 21 hours later. Okay, now, if this had happened in the middle of the night, maybe different result. But it's 2 in the afternoon. Okay, where is he? Well, yeah, he probably was sleeping over a really bad hangover from the night before. Okay, especially, there's no excuse for his absence, especially during the short days of January and in the full tide of war. Barges are constantly being drilled out. Okay, so this goes to the likelihood of harm. Okay, that it's New York Harbor, a lot of barges are being moved around, and the bargee needs to be there during working hours. Okay, all right, so that's how he uses the facts. Now, what's his conclusion? His conclusion is it was fair to require the Connor Company that employed the bargee to have a barge on board. Okay, and they also hold, if you look up a little farther, we hold that it's not in all cases sufficient answer to a bargee's absence without excuse during working hours. So what they're saying is you know, it's not necessarily that he wasn't on there, but it's 2 in the afternoon. Okay, so we've got, oh, I forgot to do the issue. Okay, the issue, if you look back on page 36, is whether, if you see the word whether, you're usually going to find an issue. Whether the damages should be reduced because the plaintiff's bargee was absent from the Anna Sea. The evidence indicated siphoning efforts by other boats to present the air allowed. Okay, so the issue is whether the damages should be reduced. Okay, because there were all kinds of parties in this case, and one of the owner of the Anna Sea, who was sued by the person that whose boat sank, cross-complained against the owners of the Anna Sea, basically saying, hey, you got to pay some money too. Okay, so what they're saying is, should the damages be reduced against the owner of the Anna Sea because the bargee was not there at the time of strike that last part. Lawyers say that a lot. Okay, the issue is whether the people that moved the barge, okay, obviously they were negligent because they let it go. Okay, the issue should be is, should there be damages be reduced because of the fact that the bargee of the Anna Sea wasn't on there. Okay, that's Carroll towing. Let's go on to Klein versus Massachusetts Avenue. Okay, the facts are at the bottom of 176. Okay, Mrs. Klein sustained injuries when she was criminally assaulted and robbed at 10:15 by an intruder in her hallway. Okay, this is a big apartment complex that has over 500 units. At the time that she originally came to the apartment, there was a doorman. Okay, there were parking garage attendants. Okay, but by 1966, the doorman was gone and the lobby was left unattended, and the garage was left unlocked a lot, and there were an increasing number of assaults, larcenies, and robberies. Okay, so what they say there, it's important at the top of 177, it was undisputed that the landlord had noticed the crimes were going on and wasn't doing anything about it. The issue in Klein versus Mass is pretty easy because it's right at the top of the page. Okay, it's right at the top of page 176 there. Whether a duty should be placed on a landlord to take steps to protect tenants from foreseeable criminal acts committed by third parties. Okay, well, you can tell by the way he frames that issue what his answer is going to be. Okay, and I've told you this in the past. The way the court frames the issue a lot of times will direct you to the answer that you get. Okay, the rule in this case is right in the middle of page 178. It says, when a landlord has notice of repeated criminal assaults and robberies, notice that these crimes occurred in a portion of the premises exclusively within his control, has every reason to expect like crimes to happen again, and has the exclusive power to take preventive action. Okay, so that's the rule. The application is at the bottom of 179. If you look there where it says risk of assault and criminal robbery was clearly predictable. The risk the landlord has specific notice when it became a reality in the very premises under his control. Therefore, the landlord had a duty to protect the tenant from injury. Okay. He again restates the rule down at the bottom. It's his duty to take those measures which are in his power and capacity to take, which can reasonably be expected to mitigate the risk of intruders assaulting and robbing tenants. Okay. He's obligated to protect those parts of the premises which are not usually subject to periodic patrol and inspection by the municipal police. Okay. That is basically the holding or the conclusion as well. Thus, the landlord was responsible or liable to the tenant. Okay, the next case is Kelly versus Greenwell. Okay, the facts are at the bottom of page 151. Okay, you can see there in brackets, basically a guy consumed some drinks at a house. On his way home, he was involved in an accident. His blood alcohol was 2.86%, so he was totally wasted. That's 13 drinks, and showed unmistakable signs of intoxication. Okay. So what is the issue in this case? Obviously, the drunk driver's liable. The issue is whether, it's right at the top of the page, whether a social host who enables an adult guest in his home to become drunk is liable to a victim of an automobile accident caused by that drunk driver. Okay. The conclusion is right there at the top too. They say we hold that a host may be liable under the circumstances of this case. So sometimes they'll have the issue and they'll have the conclusion right next to each other. Okay, so how do we get there? Okay, we have to have an application of these facts to the rule of law. Okay, they restate the rule again. If you want to look on page 153, a host who serves liquor to an adult social guest, knowing that both the guest is intoxicated and will thereafter operate a motor vehicle, is liable for injuries inflicted on a third party as a result of the negligent operation of the motor vehicle by the adult guest when such negligence is caused by intoxication. Okay, a lot of times the holding and the rule are the same because they're announcing a new rule in the case. Okay, so how do they get to that point? At the bottom of 151, here they work the facts into the rule. Under the facts here, defendant provided his guest with liquor, knowing that after he would drive and get into the car and go home. Okay, one could reasonably conclude that the Zacks, meaning defendants, must have known that giving liquor to Greenwell would cause him to become drunk. Okay, and not only that, they continued to serve him after he was physically intoxicated. Thus, a reasonable person in the Zacks position could foresee that he might kill somebody on the way home. Okay, all right, so now the rest of the case deals with why they should impose a duty. Here they are creating a new law and they're justifying it. Thousands of people get drunk. Bars are supposed to be able to, cut you off when you're drunk, things like that. And so the next step is to extend it to a social guest. Okay, that's the justification for the rule. They do, however, are not going to apply it retroactively, which means it applies to the parties in this case and going forward, but people who were hurt before the case was decided, you can't sue. Too bad. Okay, so another duty case. We'll move on to the next. I misspoke earlier. I thought I deleted Rowland versus Christian, but it was another case that I took out. So if you did that extra one, now you are required to do Rowland since I put it in there. But if you do an extra one, then that extra one that I originally did, just let me know and you will get credit. Okay, last case, the famous case of Rowland versus Christian. This is a California case. What are the facts? Right at the top. Okay. Plaintiff, while a social guest in defendant's apartment, severed some tendons and nerves in the bathroom when he was using the porcelain handle. The porcelain handle broke, it cracked in his hand, and he was bleeding, okay, and severed some tendons. Okay, now, importantly, although the defendant had told her lessor, meaning the landlord, about the handle earlier, okay, she didn't mention it to the plaintiff, saying, hey, watch out. Be careful, that faucet is cracked. Okay, all right, so those are the facts. Okay, so what is the issue? The issue really isn't clearly stated, and I'm going to just tell you what I think it is here. Okay, and the issue here is whether a landlord can be held liable for injuries to third parties other than the tenants when it's foreseeable that they may or may not be injured as a result of some negligent conduct of the landlord. Okay, now the general rule is on page 163. Okay, but there's a new rule they're going to announce in this case. Okay, the general rule is Civil Code section 1714, which says everyone's responsible for the result of their willful acts, an injury occasioned to another, for want of ordinary care, and skill in management of his property or person. So that's the general rule. Okay. Now, in this case, they're going to articulate a new rule and a new way of assessing duty in California, and it's one we still have with us to this day. Okay. If you look at page 164. Second paragraph, a departure from this fundamental principle involves balancing a number of considerations. And this is the new rule regarding duty in California that we use to this day, whether we're going to hold somebody liable for their conduct, their failure to act, or acting. Okay. The major ones are the foreseeability of harm to the plaintiff, the degree of certainty that the plaintiff suffered injury, the closeness of the connection between the defendant's conduct and the injury suffered, the moral blame attached to the defendant's conduct, the policy of presenting future harm, the extent of the burden to the defendant, and the consequences of the community imposing a duty to exercise care with resulting liability for breach, and the availability, cost, and prevalence of insurance and the risk involved. Okay, this is kind of like an amped up version of the hand factors. Okay, basically, or the hand formula that I talked about in Carroll Towing. Okay, in California, these are the factors we go through to determine if it's foreseeable that somebody could get hurt. Okay, so that is the new rule in this case. Okay, so let's kind of apply it to the facts. They don't do a real good job of analyzing each of the Rowland factors, but if you go to 167 in the middle of the page, here they say, we assume that defendant Christian was aware the faucet handle was defective and dangerous, that the defect was not obvious, that the plaintiff was about to come in contact with a defective condition, and under the undisputed facts, she neither remedied the condition nor warned plaintiff of it. Okay, so not only can they sue the landlord, but they can sue the tenant as well. Now, don't get all freaked out about suing her friend. Okay, that's not really what's going on. She probably has insurance of some type, like renter's insurance or liability insurance, and they're really going after the insurance money. Okay, all right. So the trier of fact can reasonably conclude that a failure to warn or repair of the condition constitutes negligence. Okay, so if we analyze this under the hand factor, we would look at, okay, what is the burden on the defendant? Well, the burden would be just to say, hey, that faucet is cracked in there, be careful. Okay, so a little more simple. What's the likelihood of harm? Well, fairly likely that it might crack and you might get cut. Porcelain's very sharp. And then what's the magnitude of the harm? Well, a severed tendon. You know, that's serious, but not super serious. Okay, so we use the Rowland factors to analyze duty in California, and I like them because they're really set out and you can really work the facts into the case. If I was going to analyze the rolling factors in this case, I'll just go through them for you. Okay, foreseeability of harm to plaintiff, fairly high. I mean, you know, porcelain breaks and it's sharp. Okay, degree of certainty the plaintiff suffered injury, slam dunk, severed tendon. Okay, closeness of the connection between defendant's conduct and the injury suffered. Okay, the defendant didn't warn them and they were hurt. That's pretty close. Okay, the moral blame really isn't any moral blame in this case. The policy for preventing future harm. Okay, if we impose a duty now, is it likely that people will not get hurt in the future? That's probably pretty high in this case because, you know, if you get, you know, basically makes a duty on people in your house to let them know of dangers you know about that they couldn't discover. Okay. The burden on the defendant and consequences of the community imposing a duty. That's talking about things like, you know, will it really make the cost of business going up? And the availability, cost, and prevalence of insurance. Not necessarily for tenants, but landlords certainly have it. All right, I would recommend that you, you know, do a little bit better job than I've done orally briefing these. I'm not going to brief them myself and show you examples, but try to, you know, fill in the facts a little bit better. Try to do a little bit better analysis when you do your own briefs, and it'll pay off for you in the long run. That's it for this lecture. Have a nice day.